Hello, dear listeners. My name is Vladislav Arkhipov. I'm Doctor of Legal Sciences, Head of the Department for Theory and History of State and Law at the Law Faculty of St. Petersburg State University. I'm very pleased to welcome you to the online course on legal issues related to the computer games industry. I would like to point out right away that this course was not conceived as a part of any mandatory program, and it is largely based on my individual vision of what problems can be considered as key, basic, primarily related to the very nature of games, and not to any accompanying general legal relations that arise in this area. And this course is based both on my personal experience of researching problems for almost the last 10 years and on the practice in this field, which I have been doing for about 6 years as a counsel of the international law firm Dentons. This course does not contain any general legal issues that are common to the video games industry as well as to many other industries, for instance, issues related to tax law, corporate law, and others, which seem to be more appropriate in other specialized online courses. In this course, you and I will mainly try to talk about the problems that I believe are most interesting in the special perspective of video game industry. These are legal problems that are directly related to games from the point of view of their seemingly sometimes non-serious gaming nature, to which we will pay appropriate attention from the very beginning. And in the light of this introduction, I would like to make 3 main reservations or explain the 3 main aspects of this course, which will make it possible to identify more clearly its place in the system of perception of the problem, in the system of other courses that may be directly or indirectly related to the problem in question. In my opinion, this course will be most of all interesting and useful for the following attendees: beginning lawyers who want to get a basic understanding of a given field, lawyers who practice law, who are fundamentally far from information law, intellectual property law, and for whom this course can become a basis to start immersing themselves in this topic. I think that this course can also be of interest to representatives of the video game industry who previously had no experience and interest in interacting on the matters of legal issues with lawyers, and to some extent it can be useful for them to set tasks for lawyers with whom they have to interact. Finally, it is representatives of other social and humanities disciplines, particularly in the field of game studies, for whom this course may reveal some new facets of the subject in terms of legal theory, in terms of practical problems of law. I think that this course is unlikely to contain anything new for those lawyers who have been practicing in video game field for a long time, whether they are external counsel or in-house lawyers, simply because many of the issues that are covered in this course are part of a fairly common knowledge among specialists in this narrow field. However, I do not rule out the possibility that the course may seem interesting to them as well, because it will allow them to structure their ideas a little and check with other industry representatives, including me, and the authors I will refer to. Secondly, this course deals only with those legal problems that are related to the unique features of games as such. For instance, here we will talk about the relationship between something that has game nature and something that doesn't have it, virtual and real. Here we will touch upon some issues that relate to other areas of legislation, institutions, regulations, and law enforcement. But we will also try to pay attention to those special aspects that are related to the interactive online game environment. Accordingly, issues that are related to general legal knowledge and which are only partially touched in this course will be dealt with as a part of the game environment to the minimum extent necessary or in principle left out of this course. This is, after all, an author's choice. Nevertheless, it is possible that this course will be developed further. At the same time, among practicing lawyers, the rule of good tone is to speak about the jurisdiction in which they practice, in which they are qualified, so the vast majority of the examples in this course will certainly relate to Russian law and legislation. But this doesn't mean that the course is limited to this jurisdiction only. And in the light of these caveats, this opening statement, I am pleased to announce the start of the online course, and I particularly expect that some of the issues that are presented below may seem interesting to someone, as I thought they were at the time. For instance, this concerns the question about the problem of virtual property, the very fact of its existence. It inspired me, and I became stronger in the idea that my profession was chosen correctly. I'm talking about this with great pleasure because now the practical specialization in video game law is becoming more and more common among lawyers. But as can be seen from the time frame initially outlined, I started doing this long before it became a trend, like people said or used to say in the internet. And it is with this enthusiasm that I approached this course and that I would like to share with you.